You are practically conditioned to just blindly scroll to the bottom of 50-page terms of service and hit, I agree, just to use like a basic piece of software.
Oh, absolutely. It's totally an involuntary ritual at this point.
Right. And the tech company holds all the cards, they dictate the rules of engagement, and if you want the tool, you just surrender to their terms. But today, we're taking a deep dive into a leaked stack of sources that completely flips that script.
It really does.
We are looking at a draft from the highest court in India, and they are essentially telling Silicon Valley, if you want to operate here, you will sign our terms, and they are incredibly strict.
Yeah, it completely inverts the standard power dynamic that we are so used to seeing in software procurement. Because, dealing with the foundational institutions of a nation, that requires a totally different approach than just downloading a consumer app on your phone.
Exactly, which is our central mission today.
Yeah.
We are exploring excerpts from the Indian Judicial Framework for Private AI Procurement, which is a draft suggested by the Supreme Court of India. And our goal here is to unpack how a very specific set of rules written strictly for courtrooms has the potential to actually become a master blueprint for the entire private tech sector.
And that's what makes this so fascinating.
So if you have ever wondered how governments might actually rein in the wild, unregulated expansion of artificial intelligence, this document is the practical template. Reading through these sources, honestly, it feels less like a procedural manual and more like a highly advanced corporate prenup for dealing with big tech.
I like that analogy. A prenup forces both parties to lay all their assets on the table, right, and legally define what happens if things go wrong.
Yeah.
Before this draft framework, integrating AI into a legal system was terrifyingly ambiguous. The stakes are just monumental when a system is processing justice or handling binding legal precedents and digesting the most sensitive personal data imaginable.
Right. The scope of what they are trying to regulate here is massive. So we should probably establish who this actually applies to first and who is setting these rules, because that dictates how much leverage they have. This framework, once it's adopted, is framed as a mandatory order for the entire Indian judiciary. So we are talking about the Supreme Court, all the high courts, the tribunals, statutory commissions that perform adjudicatory functions. Anywhere justice is administered within the territory of India, these rules apply.
And the sources also note a really significant ripple effect here. This sectoral framework, since it's designed under the supervision of the highest court in the land, it's highly comprehensive.
Yeah.
The text implies it's intended as a template for MeitY.
Which is the Ministry of Electronics and Information Technology in India, right?
Right, exactly. If MeitY adopts this, they would use the structural logic of this courtroom framework to draft broader AI laws for the entire country.
So it starts in the courtroom, but the underlying mechanics are designed to be exported to the broader private sector. Let's look at the gatekeepers managing this, because this is where it gets really interesting. The draft establishes an entity called the Appropriate Authority. Basically, no private tech company can touch the court's systems without prior written approval from this group.
And at the Supreme Court level, it's called the apex body.
Right. And I'm looking at the membership list for this apex body in our notes, and it is a massive, highly diverse group.
Yeah, the required composition of that committee is, I think it's one of the most revealing parts of the whole document.
They require at least 9 members. You have 2 judges from the Supreme Court, 2 judges from the High Court, a member from an institution of national importance, a joint secretary from MeitY, an expert in finance, an expert in cybersecurity, 1 or more legal advocates of standing, and a professor heading AI at the National Judicial Academy.
It's quite the guest list.
I mean, I have to admit, I look at that list and I just wonder how anything gets done. You have high-level judges, financial auditors, government bureaucrats, and cyber penetration testers all trying to coordinate a software review. The source text itself actually acknowledges it will take 2 to 3 months just to get this committee functional. Is this framework intentionally designing a bureaucratic bottleneck?
Well, it's interesting because the text explicitly anticipates that delay, but it frames it as a necessary precaution rather than, a bug in the system.
Okay, how so?
The rationale presented in the framework is that AI in the judiciary is just too complex for any single discipline to evaluate. A Supreme Court judge obviously deeply understands constitutional law, but they might not possess the technical vocabulary to audit a cloud architecture for backdoor vulnerabilities.
Oh, that makes sense. And I guess the reverse is true for the tech people, like The vendor knows the code inside and out, but has no idea how a tiny, tiny alteration in a legal document could impact a decades-long property dispute.
Exactly, which is exactly why the financial and cyber experts are at the table. The cyber expert is there to evaluate the encryption standards and data flow. And the finance expert, they're there to look at the vendor's financial runway.
Wait, why does the court care about the vendor's financial runway?
Well, think about it. If a startup is providing an AI tool that manages the entire docket of the high court, the committee needs to know that that startup isn't going to just go bankrupt and shut down its servers in 6 months.
Oh, wow. I didn't even think of that.
Yeah, so the framework basically forces a multidisciplinary interrogation of the technology before it ever touches a live court case.
Okay, so once that massive 9-person committee is finally seated and they're looking at a proposal, what specific hurdles do they make the vendor clear?
So this gets us into Chapter 6, Section 46.
Right, the vendor rulebook. The draft outlines a strict procurement rulebook, demanding that vendors prove their technical capability, legal compliance, data security practices, and financial standing. But there is a specific provision regarding transparency that, it seems nearly impossible for modern AI companies to comply with.
You're talking about the demand for source and model transparency.
Yes. The framework requires vendors to provide complete technical documentation of the system's architecture and the data it was trained on. And I am genuinely stuck on how a company like OpenAI or Google would ever agree to this.
It's a huge point of friction.
Right, because the industry standard right now is the black box approach. They feed billions of data points into a neural network. The system finds its own invisible patterns and spits out an answer. The companies themselves often admit they don't fully understand how the model arrived at a specific conclusion.
Right.
But the court is demanding explainability documentation for all high-risk AI tools.
Yeah, the framers of the document are drawing a really hard line against the black box model here.
Right.
Because in a legal setting, if an AI tool flags a piece of evidence or suggests a procedural step, the human judge has to be able to trace the logic.
You need to see the work.
Exactly. The framework suggests that relying on an opaque, probabilistic algorithm actually violates the fundamental principles of transparent justice.
It's essentially a mandate to show your math. You can't just give the final answer. You have to document the exact formula you used to get there. And if you can't show your math, you just don't get the contract.
And that demand for transparency ties directly into how the framework handles legal liability, which, honestly, is perhaps the most aggressive stance in the entire document.
Oh, the indemnity clauses.
Yes. The draft includes mandatory indemnity clauses.
Right.
These clauses protect the court from liability for harms caused by defects in vendor-supplied AI systems.
Okay, let me make sure I'm understanding the mechanics of an indemnity clause in this specific context. Because normally when a company buys enterprise software, there is an as-is clause, right?
Right, exactly.
The software vendor says, here is the tool, but if you use it and it crashes your servers or deletes your files, that is on you. But this draft flips that entirely.
It completely flips it. It shifts the liability squarely back onto the vendor. So the text implies that if an AI system hallucinates a fake legal precedent,
Which we know happens all the time.
right, because large language models are essentially just predicting the most likely next word in a sequence rather than retrieving actual factual records. So if that happens, the vendor is financially responsible for any resulting harm.
Wow.
If a defect in the system causes damage to a litigant's case, the court is legally shielded and the tech company pays.
Which completely changes the risk calculus for the tech companies. If you know your algorithm occasionally fabricates information, you are not going to sell it to a Supreme Court if you have to foot the bill for the ensuing lawsuits.
You'd have to be crazy to take that risk unless your software is bulletproof.
The draft also mandates continuous monitoring and periodic audits by an AI secretariat, and vendors have to report any data breach or AI incident immediately. They can't wait a week for their PR team to figure out a spin strategy.
No, not at all.
If they hide an incident, the text says they face immediate suspension or termination of the engagement.
And see, demanding transparency and accountability is really just the first layer of defense here. The second, much thicker layer of defense involves the actual data.
The crown jewels.
Right. The most valuable asset in the modern tech economy is the data used to train these models. And the judicial system generates an immense amount of incredibly sensitive, highly structured data.
We're talking court files, witness testimonies, proprietary financial documents submitted during corporate litigation. It is an absolute goldmine for an AI company looking to train a model on legal reasoning.
Oh, a total goldmine. And the framework anticipates this and sets absolute boundaries. The draft explicitly prohibits the retraining, fine-tuning, or modification of AI models using court data without the express written approval of the AI committee.
So the tech company cannot absorb the court's files to make their own commercial chatbot smarter. They are totally walled off.
Completely walled off.
And for what the document calls sensitive judicial data, they actually require on-premise or sovereign cloud deployment. What exactly does sovereign cloud deployment mean in this context?
So, sovereign cloud deployment is a critical technical mechanism here. It means the data architecture is physically localized within the country's borders and subject exclusively to local jurisdiction.
Got it.
The court's data cannot be routed through a server farm in another country where a totally different set of privacy laws might apply. It is digitally air-gapped from the vendor's global network.
I am looking at another highly specific clause here regarding ownership. The draft states that where AI tools are developed using court data or court resources, the authority ensures the court retains ownership of or a perpetual royalty-free license to the resulting tool and its outputs.
Yeah, that's a big one.
Furthermore, it says no private entity shall claim exclusive intellectual property rights over tools developed primarily using judicial data.
The text establishes a rigid principle of purpose limitation, meaning the public data exists strictly to serve the administration of justice. Period.
I have to play devil's advocate here, though, because from a purely commercial standpoint, this seems like market suicide.
How's it?
Well, if I'm a leading tech vendor and I spend tens of millions of dollars building a bespoke AI architecture for the court, and the court uses my tool to process their data, this draft says I can't claim exclusive IP over the final customized product.
Right.
I also can't use the learnings to improve my commercial products. Why wouldn't a Silicon Valley giant just walk away from this deal? It seems like all risk and no reward.
It is a profound market tension. The drafters of the framework are operating on the assumption that the institution itself is the prize, not the algorithm.
Oh, interesting.
Think about the sheer volume of the Indian judicial system, the thousands of courts, the millions of pending cases that represents a massive, highly lucrative contract.
So they're betting on the scale of the money.
Exactly. The text suggests a dynamic where the government believes the prestige and scale of the contract will force tech vendors to adapt to the public sector's rules rather than the government capitulating to tech industry standards. Whether vendors actually accept those terms or abandon the procurement process, well, that is the ultimate stress test of this framework.
Right. Now, if a vendor does accept the terms, we still have to think about the practical reality of running a court system. We just talked about how it takes 3 months to get a 9-person committee to agree on an audit.
Yeah, it's not fast.
If the rules are this rigid, how does a court buy a simple piece of software to, I don't know, schedule courtroom times without grinding the entire legal apparatus to a halt?
That's exactly why the drafters carved out specific pathways to prevent bureaucratic paralysis. They recognize that not all AI poses an existential threat to justice.
Okay.
First, they address the legacy systems. The AI tools that courts are already using right now.
Because you can't just unplug the court's existing infrastructure the day this framework goes into effect. The courts would just stop functioning.
Right. So the text grants a 1-year grace period for legacy systems. The AI Secretariat will conduct compliance reviews over the course of that year. If an existing vendor fails the new transparency or data sovereignty tests, the authority decides how to phase them out.
So existing vendors are on notice. What about new tools that are very low risk, like the scheduling app I mentioned?
For those, the framework introduces an expedited 30-day approval track, which completely circumvents the standard multi-month review.
Okay, 30 days is much more reasonable. What are the technical qualifications to get on that fast track?
The draft lists 3 strict conditions.
Yeah.
First, the AI tool must be exclusively for administrative purposes. Meaning it handles no personal data of any parties involved in litigation.
Oh, okay.
Second, it cannot affect adjudicatory functions. It has absolutely zero input on legal decision-making.
Makes sense.
And third, it must be functionally similar to a tool already approved by the appropriate authority.
It functions almost like a TSA pre-check for software.
Well, that's a great way to put it.
If the vendor can definitively prove their algorithm is just organizing digital folders and has no access to personal files and absolutely no ability to suggest legal outcomes, they get to bypass the heavy security pat-down and get installed in 30 days.
The pre-check analogy is highly applicable here because, just like airport security, you only get access to the fast lane if you have already submitted to a background check that proves you aren't a threat.
Right.
It isolates the intense, multidisciplinary scrutiny for high-risk decision-making algorithms while allowing basic operational software to deploy efficiently.
The source text also highlights an alternative way vendors can build trust early on. It explicitly references something called the DGPSI-AI developer framework.
Yes, the Data Governance and Protection Standard of India.
Right. The notes detail that the court's draft framework purposefully mirrors the 13 implementation specifications of this DGPSI model. Now, DGPSI is a voluntary self-regulatory standard. It is not legally binding on its own.
No, it's not.
But the text indicates that if a tech company voluntarily builds their AI to meet DGPSI specifications like hard-coding data minimization protocols or maintaining immutable access logs, their journey through the court's approval process might be significantly smoother.
Because the framework is essentially leveraging behavioral economics. It incentivizes a race to the top.
Reward the good behavior.
Exactly. The drafters are signaling to the market that if a vendor absorbs the cost of implementing rigorous data governance voluntarily, the government will reward them with less friction during procurement. It is a structural attempt to make safe AI development more profitable than reckless rapid deployment.
Let's pull the lens back a bit and look at the aggregate impact of all these sources.
Oh.
When we analyze this draft from the Supreme Court, we are looking at something far more significant than just a localized IT policy.
Absolutely.
We are looking at a highly visible, comprehensive blueprint for sector-specific AI regulation.
And it's a blueprint with real teeth. By demanding source and model transparency, enforcing strict liability through those indemnity clauses we talked about, mandating sovereign cloud infrastructure, and absolutely prohibiting data retraining without consent, the judiciary is meticulously shielding its operations. But simultaneously, it provides a master template for how any massive institution can negotiate with tech monopolies.
Which brings us entirely back to why this specific legal draft matters to you listening to this deep dive. Think about the proprietary software your own company uses, or the medical portals that hold your health records, or even the banking apps that track your finances.
It touches everything.
It really does. The prevailing narrative has been that tech companies are moving way too fast to be regulated, and that institutions just have to accept opaque algorithms as the cost of doing business in the future. But these regulations propose a completely different reality.
They do. They suggest it is entirely possible to force tech companies to surrender their intellectual property claims and open their black boxes, provided the institution has enough leverage and a strict enough rulebook. And the mechanical blueprint for how to do it has now been drafted. The legal mechanisms are no longer theoretical.
Right. We don't have to operate under the assumption that clicking "I agree" to a tech giant's terms is our only option. The institution can demand that the tech giant clicks "I agree" instead.
And that framework leaves us with a fascinating strategic question to consider regarding the broader economy.
What's that?
Well, if the judicial system successfully walls off its data and forces vendors to abandon the black box model just to get a government contract, how long before other critical sectors notice?
Oh, man.
Right? If you are a hospital network or a multinational bank, and you see that the Supreme Court managed to shift all liability onto the software vendors while retaining full ownership of their data, you're going to copy and paste this exact framework for your own procurement.
Why wouldn't you?
Exactly. The question is whether this draft courtroom policy inadvertently triggers the beginning of the end for the free-for-all era of global AI data harvesting across all major industries.
That is the exact tension we need to be watching, and it is something for you to mull over as you look at how your own data is being utilized out there. Thanks for joining us on this deep dive into the sources today.